Hi, I'm Roseann Vanella, professional mediator at Advanced Mediation Solutions. Today, I've invited Diana Schimmel, attorney, here to speak with me in order to educate on how couples can still go through the mediation process and end up with a binding agreement, even though the courts are limited and closed right now. So let me introduce to you Diana Schimmel, who is attorney and partner at Martine Katz, Scallon and Schimmel, a boutique law firm that focuses exclusively on family and matrimonial matters. They're based in Cherry Hill, New Jersey, but her firm also has offices in Princeton and Philadelphia. Diana has been practicing for over a decade, and she strives to ensure families that are going through divorce have a process and an understanding of the process, and also understand their rights, and that they can navigate the process with confidence. She lives in New Jersey with her husband and her one-year-old child. Hi, Diana.
Hi, Roseann. Thank you so much for inviting me. I think this is a really important conversation.
Thanks so much for joining me, Diana. I know that, like everybody else, we're all working now remotely. We're doing it virtually. So I appreciate you taking time. So many couples, whether they've been thinking about divorce or they're ready to proceed with the divorce, everybody's really confused right now because we're all hearing that the courts are closed or they have limited availabilities. And it's important that you and I can sit here and have a conversation as experts and really guide people on how they can go through the process. So, Diana, what I'd like to do today is start with the process of mediation. And what I'm going to do is I'm going to explain, and it's basically almost like a consultation I would give clients when they're interested in mediation, but explain how, Diana, they can use the expertise of an attorney in either going through the process or finishing up the process.
I think that's really smart. And one of the things that you and I both are striving to provide to our clients these days is an alternative option when some of the usual paths that we've seen or explored are no longer available in light of circumstances.
Yep, definitely. So let me begin by saying that for couples who have decided that they feel that they can utilize mediation as a tool in going through their divorce, it's still available. I'm here, mediators, we're here, and we're doing it all virtually. So we're meeting with clients virtually. So when couples come to mediation, typically they're working through all of the issues that you would have to work through in divorce, no matter if you're going through by being represented by an attorney or by utilizing the mediation process. So we're going to cover creating a parenting agreement, talking about parenting schedules. It goes way beyond that. We talk about basically everything that you're going to have to make decisions on for your children from now until when they're emancipated. After that, we're going to talk about and establish if there's a need or a request for spousal support, which is the old alimony. And then we're going to talk about child support and determine that. And lastly, we're going to get to the equitable distribution. So some couples, while they're going through the mediation process, decide that they want to have the assistance, each of a separate attorney, kind of in the background, helping them through the process. So Diana, if you can kind of explain, how that's worked with some clients and how you provide that support, that would be great.
Absolutely. So there's two scenarios that I see that lead us to that mediation legal collaboration. Sometimes a client will come to me first, and I'll hear from what they're telling me about their goals and the level of communication between their spouse that they're ripe for mediation. And I'll recommend that they speak with a highly trained mediator like yourself. And I provide counsel before and after session. The converse is true in the other option, which is when they've come to you first before having legal advice, but they have questions throughout the mediation process that as a neutral third party, you aren't able to give them more information about. Clients often will feel a little bit more empowered with some confident knowledge going into a session or if they feel like after a session, they're a little shy to ask a question directly in the mediation, or they don't want to have their spouse here, and they want to brainstorm it with someone who is a truly unique, advocate for them, that's where I come into play, and I'm able to explain to them some of the legalities of it, some of where they're actually being able to be creative in mediation, and give them some of a projection about what could happen if they weren't in mediation, which helps them realize that the route they're going through by utilizing the mediation process is actually beneficial to them.
So I think the important thing also that we communicate here is that it's really important that if you're going to have the support of an attorney while you're mediating, is that that attorney needs to be mediation friendly. So Diana and her firm, all of the attorneys at her firm absolutely support mediation. So a lot of times clients kind of have that fear in thinking that an attorney wants to blow this up, right? And make this go on and on and on. No, absolutely not. There are plenty of attorneys, especially Diana and her practice, that are mediator friendly. The other scenario is where couples go through the mediation process and they decide that they don't want the assistance of attorneys. So when we're all finished with the mediation process, a couple who has children will leave the mediation with the actual parenting agreement that is actually drafted for them, and also with a memorandum of understanding. And the way that I explain the memorandum is that it's basically their divorce decree in layman terms. Mm-hmm. So it covers absolutely everything that we've discussed and agreed to. So at that point, if the couples decide they each want to have an attorney review it, that's where they would turn to an attorney like Diana, who would basically go through the agreement and review it on that party's behalf. And at that point, lend to any kind of advice that needs to be given. Now, the other scenario is where the parties have gone through mediation, they've finished, they decide they don't need review attorneys, they want to get their divorce either finalized with the courts, or, and this is where the big concern is right now during COVID-19, is how do we get this to be legally binding? So what I'm explaining to new clients is that you don't have to file with the courts for it to be legally binding. Diana, I'm sure you're experiencing what I'm experiencing, that right now, as we're going through and we're helping couples through this divorce process, with so much uncertainties out there with many clients, we need to not only be creative, but we need to be flexible. So I'm drafting many agreements that are basically putting the scenario forward of how things are going to work today. And either those issues are going to be revisited or renegotiated once life comes back to somewhat to a normal standard.
I completely agree, and I think you made a nice distinction about what a memorandum of understanding looks like, and it's the layman's terms version. My job then is to translate those terms into legalese and put them into a marital settlement agreement. And you're 100% correct. Once a marital settlement agreement is drafted and signed by both parties, it is a legally binding and enforceable document. So whether or not you're able to take that next step, able or want to take that next step to file your divorce complaint and get that final judgment or divorce decree, that marital settlement agreement still is a legally binding document. Now, as the last few weeks have evolved, the courts have taken steps to try and accommodate. In New Jersey, we're seeing that courts are still accepting filings, and if you are in a position where you've mediated your full divorce and you have an executed marital settlement agreement, you can appear for what's called an uncontested final judgment and divorce hearing. These used to be in person in some counties. Other counties would put them through on just the paperwork alone. But what's happening is they're holding a conference and not delaying the process of getting you that final judgment and divorce, that legal divorce decree, so that you can actually see some semblance of resolution there. In Pennsylvania, there's some mixed scenarios depending on which county you're in. They're a little more county specific there. Some counties are accepting filings, others are not. Some are scheduling conferences, others are not. All the more reason to take control of the situation, use the time while the courts are down to get that agreement in place, because that is legally binding.
Okay, that's great information. So, couples don't have to feel stuck. They have the flexibility that if you're laid off from a job, you don't know where you're going to be in 6 months or a year from now, there's always a solution. So working with professionals like myself and Diana, we're here to use our expertise to help you. So always feel free to reach out to either one of us. I'll have our information probably on the bottom of this video. But Diana, this was so helpful, and I so appreciate your expertise, especially at a time like this where people are so stressed out. And the more information they have, the more they can feel they're in control, and also know that they're not going to be held hostage to the courts or to anything that's happening, that they can move forward and make sure that it's all covered and it's legal. So
Absolutely.
Diana, thanks so much for joining me today. This was great.
Thank you for having me. I think that a lot of people can benefit from this resource. And since we're able to video today, hopefully a lot of people are able to see what we had to say.
Great. Stay healthy and well, Diana.
You as well. Take care.
Bye-bye.